All right, thank you very much. We're going into part two now of the contracts exam crash course. And again, a reminder, you can go to www.lawbarcoach.com and set up a one-on-one tutoring appointment with me in contracts or any other first-year law school topic, class, or the multi-state bar exam. So let's get right on to the second part, and we're going to talk about consideration. I mentioned it in the first part that a contract is only a contract if it is backed by consideration. Otherwise, it's just a gift. If I make a gift, that's a nice gesture, and I might be a jerk if I don't follow through and deliver the gift, but the government doesn't get involved. The state doesn't get involved, the courts don't get involved. A contract means that a promise is legally enforceable. When do we want the courts to get involved? When it's important. When it benefits the economy. When the parties want the courts to be involved. You make a contract with someone because you say, if things go wrong, I know I can bring you to court. And you can bring me to court too. That's only fair. It would be very unfair if one party got to bring the other one to court for a promise, but he had no obligation himself. If I told Bill, I'll give you this painting. I'll bring it to you on Tuesday. I know you like it. I want to give you this painting. I never bring it. Bill goes to court and says, I was promised a painting. I never got it. The court says, well, was there consideration? And Bill says, no, but I was told I was getting a painting. And the court says that's unfortunate. You might choose to no longer be friends with that person, to warn other people, but you needed consideration. It was a gift. There was no expectation that this could become a legal matter. In other words, the person was not on the hook. Consideration is an interesting term. You could say, because it's not really just money, right? What would consideration have been for the painting? All right, I'll deliver you the painting on Tuesday if you pay me $50. In consideration of me delivering a painting, you will hand me $50. But it doesn't necessarily have to be money. I'll deliver the painting to you if you give me a little statue figure that I like, that you have. We're going to make a swap. We agree to do that. It's not a gift anymore because we're both giving each other something. Now, I've tried to illustrate what consideration is, but it's a very difficult topic, and there is no really good answer. But there are some terms of art, some classic ways of looking at this that are important for purposes of an exam, because inevitably there's going to be an issue on one of your questions regarding whether or not there was consideration to a contract. So let's take a look at the traditional common law definition. This is old, obviously, but it doesn't mean it's wrong. It's just the terms itself is a little outdated here. We talk about it being one of two things, either a benefit to the promisor or a detriment to the promisee. Now, the painting example, I'll give you a painting and you pay me $50. In consideration of me delivering a painting, you will hand me $50. If I promise to deliver the painting, that means I am a promisor. Does the $50 benefit me? Sure does. I get $50. Does it detriment the promisee, the person who's receiving the painting? Yeah, he loses $50. It benefits me, and it's a detriment to the person that's receiving the promise. The modern definition talks about a bargained for exchange. Now, what does this mean? Let's I like to think of this as, well, what was your end of the bargain? What were the two ends of the bargain? I decide to deliver a painting for nothing in return. That my end of the bargain is to deliver a painting. What's the other person's end of the bargain? Well, they have to be home to deliver to accept the painting. Now, theoretically, that's a detriment, right, to the promisee. He has to be in a certain physical place at a certain time. But that's not really a detriment, is it? It's not that big of a deal. Well, what if it was a big deal? The classic example is the tramp. I think it was Williston who gave this. It's really odd. That if, imagine there's a homeless person and someone says they want to get him off the corner, and they say, oh, go around a couple blocks away, there's a store, and on my credit you can buy a coat. So in other words, if you leave this block, I'll get you a coat. The poor homeless person gets up, goes to the store, and there doesn't exist. Now, was there a contract? There was a detriment because the homeless person had to get up and leave, right? So you could say, well, that's your detriment right there, detriment to the promisee. Or was that just a condition of receiving a gift? My gift to you is a coat. In order to get that gift, you have to go to this clothing store. That's the condition. He gets to the clothing store and I revoked my gift. No more gift. Whereas the idea of a bargained for exchange looks at the two ends of the bargain. The person says, my end of the bargain is I'm giving you a coat. What is the other end of the bargain? I'm walking to a store. That's not an end of the bargain. That's a condition to receiving a benefit. So, if he said, I'll give you a coat if you pay me $50, well, what's one end? The one end of the bargain is giving a coat. The other end of the bargain is paying $50. Or if the tramp, we can word it a little differently, but make it similar. I'll give you a coat if you promise not to be on this corner for the next month. Now, that's not a condition for receiving a coat anymore. That's an actual end of the bargain. You see the difference? Walking to the store and leaving right now, that's a condition. You have, in order to get the coat, you got to go to the store. But if he says for the entire month I'll leave the corner, then that's my end of the bargain. So it can be a promise for a promise for an act, a promise for money, a promise for a forbearance for not doing something, like the tramp saying, oh, I won't be on that corner. So he's, a forbearance is, you can look at it more than one way. You're obviously, what are you doing? You're not being someplace. So you're still promising to do something, but you're essentially promising to not do something because we don't care where the tramp goes as long as he's not in the corner. So again, think of it this way. What are the two ends of the bargain? That's the bargained for exchange. It doesn't actually have to be bargained for. They don't have to have serious negotiations, anything like that, but there needs to be two ends of the bargain. And not only that, but the another factor is, does the consideration evidence a willingness to be in a contract? If I promise to give the painting, you promise to pay money. Those two ends of the bargain, that people only do that if they want to be in a contract. All right, I'll accept the money. I'll give the painting. I understand that's a contract. Now, the fact that you put $50 on the table and we've shaken hands means that I'm willing to get the courts involved if necessary. If I say, wait a second, I'm just doing this as a favor to you. I don't want any money. Now, I don't want the courts involved. It's a gift. False consideration. Well, it's an oxymoron. There either is consideration or there isn't. But for our purposes here, we can discuss this. So, consideration has to be fresh. Consideration must be unique to the contract. If you already did something or you already owed somebody something. It can't be consideration for a new contract. So the painting example, I'll give you a painting if you pay me $50. What if the person already owed me $50 and says, I got an idea, I'll pay you the $50 that I owe you if you give me a painting? Well, that's not a contract because there's no fresh consideration. There was nothing new. There was nothing new. The person already had to pay me $50. That's not a bargained for exchange because there's nothing to bargain for. He already owed me $50. So again, why is that the case? Because the government, the state, and courts only enforce agreements that are economically viable, legitimate contract agreements. If someone already owed somebody $50, why are they going to enforce that? You already had to pay. Moral consideration. This isn't that, I mean, this is just getting into the fact that some sort of moral duty, you were saved and you're promised to pay somebody. I mean, again, that goes into sort of past consideration, but it's this idea that we need a tangible, legitimate piece of consideration, money, a promise to do something, a service. Illusory promises. The reason why we're talking about this in the context of consideration is because a promise can serve as consideration. I promise to deliver a painting if you promise to mow my lawn once a week for a month. My end of the bargain is giving a painting. Your end of the bargain is a promise to mow my lawn on a future date. That's fine. It serves as consideration. It's your end of the bargain. But, so in other words, so consideration has to be real. What if that promise that you're making is illusory? I promise to give you a painting if you promise to do a service for me. Well, what service? That's not real. What if I said, I promise to give you a painting if you promise to do anything you would like in return for me? That's not real. That's nothing. Well, how would a court enforce that? The court would say, well, that's not a real contract. You can't contract. Consideration can't be something that doesn't actually exist, or can't be quantified, or can't be understood. And included in that is an unrestricted right to cancel. So if I said, I promise to deliver a painting, you promise to mow my lawn, but you can stop mowing the lawn whenever you'd like. Well, that person could theoretically never mow the lawn. All right, I will never do it. Then there was no consideration. And they could have mowed the lawn, but the idea is that it doesn't exist. It's illusory because they theoretically could never do it. Or if a promise is dependent on a party's satisfaction. If someone promised to build a house that is approved by that meets the satisfaction of the new homeowner, and there's no qualifications to that. Well, what does that mean? How do we get inside someone's head to determine when they are satisfied? Or they can just always say, "Oh, I'm not satisfied. This doesn't satisfy me." It's not real. Some courts will add in an implied term of good faith there. Well, that satisfaction has to be objectively measured. That you can't be unreasonable if you're saying that something is dependent on satisfaction. Now, what does this mean here? The mutuality rule. This means that there must be mutuality of consideration. Both sides have to have consideration in order for there to be a contract, right? I'll give you a painting, you pay me money. In consideration of me giving you a painting, you give me money. In consideration of you giving me money, I give you a painting. But if one of those promises is illusory, then it lacks mutual consideration. It's not a contract. So this is different than a condition, though. A condition just says when a promise goes into effect or stops going into effect. If I make a contract that says, if I decide to move to San Francisco, you will pay me a certain amount of money, or you'll do something. That's totally in my control. And some courts might look at that and say that's illusory because there's nothing real about that. Whereas if I said, if San Francisco Giants win the World Series, I will provide security for the parade. That means that's the condition. There's no sense in me supplying security for a parade if they didn't win the World Series. In other words, that promise goes into effect only if a condition is met. And if they win, I give security, and you pay me for being a security, for providing security. Another way of looking at this is if I said, "Oh, you have to mow my lawn until I tell you to stop." That's illusory. How do I know when you're going to say stop? You might make me mow your lawn forever. But if I said, you have to mow my lawn this year until the first freeze of the year, well, that's a condition subsequent. My promise to mow the lawn extinguishes when a certain condition comes about. We don't know when the first freeze might be, but we can. It's not fake. It's not just up to somebody's whim. The freeze will come, and then it extinguishes the promise. Now, the parties are in a position to try to predict when the freeze might come, and they'll make the price around that. So someone might say, "Oh, I think it's going to come really early this year, so I don't need to charge that much." And they might lose out. It might come very late. They have to mow a lot of weeks that they didn't think they would have to. But nonetheless, that's totally fine. Promissory Estoppel. Again, this is an equitable principle because this is not exactly a contract by the terms that we've stated. It is not a legally enforceable promise. In other words, it is not a promise that is backed by mutual consideration. It is a situation where remedy is granted as justice requires. The idea is justice, fairness, equity. The promisor should have expected to induce an action or a forbearance. The promise was definite and substantial, and that, in fact, the action or forbearance is induced. So, if I promised to make a certain gift, I said to somebody that I would, that I said, you know what, I'm going to show up to your house this Saturday and install a patio for you. If you would like me to, I'll be there and I'll do it. Let's say this person, for whatever reason, couldn't install patios on their own. They were handicapped. I'll come do it for you on this Saturday. I'll be there. Yeah, go ahead, get the stuff. I'll be there Saturday. I never show up. The person bought the equipment. They bought materials for me to do this favor for them. So I made a definite and substantial promise. I said I'd be there Saturday to make a patio for them. And I should have reasonably expected that they'd go and buy materials to build the patio. And you know what? They did. They bought this stuff. And then I never show up. And that's wrong. Justice requires that they be able to sue me for the damages. This happens when people make charitable gifts and the charity or the recipient does something in reliance on that. If somebody said, I'll pay the last remaining amount of money, that way a university can build a football stadium to finish, I'll pay for the second tier. They start building the stadium and I say, oh, sorry, I can't do that anymore. And they say, no, you have to. We started building the stadium because you said you would do that. It was reasonable for them to rely. This also happens in some cases with construction contracts, like a contractor makes a bid relying on promises that have been made by subcontractors. So I'm going to create a 10-story. I'm going to submit a bid to build a 10-story building in a city. I called up a plumber, and he said that he could do all the plumbing for me at a certain price. And I said, okay, I'm going to go make a bid now on that. I make the bid, I win, and he says, sorry, I can't, no thanks anymore. And I said, well, you made a promise to me. You knew what I was going to do. You expected what I was going to do. It was definite and substantial, and I went ahead and did it. Now, either A, you have to do this for me, or you have to pay the difference for whoever I have to hire to do that, expectancy damages. So this wasn't a contract by the letter of the law, but the court is going to enforce it as such. Here's another. We talked about fresh consideration. We'll talk about it again. This is the notion that any contract requires fresh consideration. If someone already has a duty to do something, it doesn't count, for the most part. If someone already is under contract to do something, they can't use that as the basis of a new contract. The classic example, there is a ship. The guys on the ship go to the captain and say, guess what? We want you to pay us X percentage more now, or we're going to stop working. The captain says, all right. They go back home. He pays them the original amount. They said, we changed it. And he says, no, we didn't. You thought we did, but contracts require fresh consideration. You already were under contract to be deckhands for me. So if you already had to do it. So we couldn't make a contract for a different price because you already had to do it. Meaning, if I didn't make the new contract, you would still have to do that stuff anyway. There's a public duty, is the idea of, say a cop is assigned to work a baseball game on a certain night, and then he calls up the baseball team and says, will you pay me to be security for you that night? Well, he can't do that. He already has a public duty to provide security for them. Duty to third parties. Now, this is sort of interesting here. And courts go both ways on here. It's worth making counter arguments on your exam or seeing what cases you've read in your class to see how it's come out. But if you have a duty in one contract or under one context to do something, can you charge someone else to do it? So here's an example. I'm arrested for something. Community service, they say that I have to mow the lawns of people in the neighborhood. They tell me I have to mow Mr. Smith's lawn. And I say, well, I might as well make a buck doing this. I call Mr. Smith up and say, will you pay me $10 to mow your lawn? He says, yeah, sure, I mow the lawn. I had to mow his lawn regardless if we made that contract. That's not fresh consideration. I was already under a pre-existing duty. However, what if I was told by the court, oh, you have to mow lawns for people in the neighborhood, but you can decide whose lawns. Just any 5 lawns will do. I say, all right, I'm going to make a buck. I'm going to call Mr. Smith up and see if he says yes. If not, I'll call up Mr. Jones until I get 5 people in the neighborhood who are going to pay me to mow their lawns. Now, that could be another example of something against public policy, that contract, because I'm taking advantage of the punitive nature of community service and whatnot. But, you know, the idea here is that there's sort of a scale between how far your duty went. Did you actually have to do that lawn, or is it that you had to do lawns in general? And essentially what I'm selling Mr. Smith is my discretion to choose his lawn. There's many different ways you can argue that. The UCC, if we compare this to UCC Section 2209, contract modification does not require fresh consideration to be binding, or any consideration to be binding. That, which is different than when we talked about the pre-existing duty, the guys on a ship who said, we're going to pay us more or we won't work. UCC is very liberal in allowing contracts to be modified. The idea being, as between merchants, they do business a lot, there's good faith between them, they need to quickly be able to change things in response to market, in response to customs. and they can be able to call each other up and say, we need to change things around. Is that okay with you? Yes, it's okay with me. Let's go ahead and do that. Obviously, put that in writing, however. Offer and acceptance of a contract. We establish that a contract is a legally enforceable promise. Well, the parties have to come to that agreement, right? Somehow. They need to agree, yes, we want to have a promise and we want it to be legally enforceable. All right. How is that done? Someone makes an offer and someone accepts. I offer you to enter this contract with me that will be legally binding because, after all, it's a contract. Do you accept? People aren't mind readers, though, right? They have to somehow, without going inside each other's heads, come to an agreement to manifest, communicate their intentions. If I say to somebody, again, the painting example, I will deliver you a painting, they have to know what I mean by painting. They have to know what I mean by deliver. They have to know what I mean by dollars. Do I mean Canadian dollars, US dollars? There's a lot of things that need to be agreed upon before we can legitimately enter a contract that we both agree on, that we both want to be binding. The idea is that there needs to be a meeting of the minds. Our minds came together. We both wanted something. We both wanted a certain exchange, and we understood what each of us wanted, or we had reasonable expectations of what we each wanted, and we decided that, yes, this will be binding. So there needs to be mutual assent. Both parties have to know what the contract's about, what the terms are, and so forth. Secondly, like I said, there's no mind reading involved. So if I say, I will sell you a painting, or better yet, I will sell you a Picasso painting, and I give the name of the painting, and the person says, oh, absolutely, I would love to buy a Picasso. How much? $100,000. We make the deal. I deliver a painting by Billy Picasso, a kid in the neighborhood. The person says, that is not a Picasso. I say, yeah, that's a Picasso. Well, when someone says Picasso and $100,000, it is you can objectively and reasonably take that to mean that it is a painting by Pablo Picasso, right? A person reasonably would rely on that. You needed to say that it was by your friend Picasso and not by the real person, if that was the case, because I was entitled to reasonably rely on what you said to have a certain meaning. The meaning being that it was by a famous person. So this gets into a distinction about what do words mean. So, what does the word Picasso mean? What does Pablo Picasso mean? Who is Pablo Picasso? Well, he is a famous painter that lived during whatever time period. Okay, well, did we have to also say that? Like, how much do you have to define all of these terms? If we made the parties have to write his entire biography out to establish who we were talking about, that would take a lot of time. And so we allow people to attach the objective and reasonable definition of terms. If you say Picasso and the contract is for a $100,000 painting, the courts will interpret that to mean Pablo Picasso. So, and how else do we understand the meaning of terms in a contract? Context is very important. If it's based on how did the parties come about? How do they normally talk? What kind of industry is this? If certain industries have certain terms. A barrel, for instance, if you're selling oil, means something to that industry. They don't have to redefined what a barrel is every time they say I'm selling a barrel of oil. So the standard, the way I like to phrase it, is as a reasonable person in the position. What the court says is this. Again, anytime a contract is litigated, it means there's a dispute. The parties are disagreeing about something. They go to the court. There's two different versions of, say, what the word Picasso means. I say it's the famous person Picasso, and someone says, no, I say it is some random guy named Picasso. The court now says, all right, well, what would a reasonable person in the position have interpreted that to mean? Any reasonable person would have interpreted that to be Pablo Picasso. You don't have to go inside someone's mind. You don't have to see if they're scamming you. You don't have to follow up later on to do fact checking. You can rely on the definition that a reasonable person in that situation would have attached to the term. What is an offer? An offer is a manifestation of a willingness to create a contract. If someone says, yeah, this car looks good, I bet you it's worth $5,000, I've had it for a long time, I'm thinking about getting rid of it, I'm thinking about selling it. Someone can't shake my hand and say, deal, $5,000. I said, well, I didn't say I was selling it. I need to manifest my willingness to create a contract. A for sale sign. If I say, I will sell this to you for $5,000. So by language, I will sell it to you. Context, the example from earlier, a gas station that has the pumps outside with a price. In that context, any reasonable person says the gas will be sold at the price on the sign. It's available it's not a gift. It's available as an offer to sell it. An offer, it doesn't have to be express. The parties could have, every week, these people could make a certain deal with each other, and all they have to do is wink or shake hands or nod, and they know what they mean. They know what each other means. Customs of an industry, how things are done, how specific your language is, and you also think about how they're actually speaking to each other. Terminating the offer. So if I say, I will sell you my car for $10,000, you don't have the rest of your life to decide if you're going to buy my car. It can be the offer can be revoked. I can call you up and say, sorry, the deal's off. I no longer want to sell you my car. I can do that. I can do something an act that manifests my desire to terminate the offer. I say I'm going to sell you the car. You leave, you think about it, and the next day I sell it to someone else. I revoked. If the car was destroyed or I died or you died, also it terminates the offer. How do you communicate that you've revoked an offer? Implied, I sell the car, I do something like that. Or express, I call you up and say, sorry, no longer for sale. What is a firm offer? Firm offer is saying that I'm going for a certain amount of time, I'll let you decide. I'm thinking about selling my car, or I will sell my car to you for $5,000. You have a week to decide. Traditionally, remember, contracts need consideration. So I'd say I'll give you a week to decide. You come back 5 days later, and I say, I sold it. And you say, well, you said you were going to give me a week to decide. And I say, well, we didn't have a contract that I'd do that for you. That's a forbearance. That would have been a promise not to sell my car. So in other words, that was really just a gift I was giving, and I decided not to give you the gift after all. Remember, there's promissory estoppel. If I knew he was going to rely on that firm offer and do something, I might have to be responsible for it, but probably not. Because how do you rely on, in that instance, the only way that I would expect him to detrimentally rely is if he actually accepted the offer and did something. Well, that's too complicated to get. That's not worth getting into. The idea is that traditionally, if you want a firm offer, you have to pay for it. I'll tell you what, here's $10 if you hold this deal open for another week. Okay, sure. then in that instance, the offer does have to be held open. Under the UCC, however, it's a little more liberal about firm offers and how long they can last, and you might not need consideration at all. A unilateral contract in terminating an offer. This is an interesting one. I say to somebody, the first person that climbs this mountain, I will pay them $200. Bill says, okay, I'll give it a shot. He starts climbing the mountain. He gets almost to the top, and I yell up, sorry, I've terminated my offer. No can do. If someone has begun performance, the offer has to remain open. But as Bill's going up the mountain, I think to myself, ooh, I hope I don't have to pay $200. I don't know what I was thinking. Bill fails. Has to come back down. At that point, I could say, everybody else, guess what? The deal's off. I'm not doing that anymore. No one can climb it for $200. I can then extinguish or terminate the offer at that point. Rejecting an offer. Rejecting an offer is different than waiting, or, I said before about the idea of the car. I'll sell you my car for $10,000. All right, you go home. I'm not sure yet if I'm going to buy it. I'm going to go home and think about it. Okay, I haven't rejected, or the person hasn't rejected anything. They're just taking time to decide. They just haven't made a decision one way or the other. Rejection is if they call up and say, sorry, I'm not going to take it. That ends the offer. It's over at that point. A counteroffer also terminates the offer. If the person calls me up and says, I'll tell you what, how about $9,000 for the car? And I say, sorry, no. Then they can't be like, all right, fine, $10,000. I'll accept. No, the counteroffer extinguishes the offer. Now, why? Because a counteroffer is a completely new offer. If I say, I will sell you my car for $10,000, someone gets back to me and says, I will take it for $9,000. They've essentially thrown the $10,000 offer out the window and created a new offer. Now I'm the one that gets to decide whether I will accept that or not. I can accept that. If I say no to them, then there's nothing on the table anymore. The mirror image rule essentially says that the offer and acceptance have to be the same thing. If I say I'm selling my car for $10,000, I can't get a handshake that says, great, we have a deal, but for $9,000. No, it has to be for whatever the original offer was. The last shot in Battle of the Forms, last shot is the idea is where the offer and the acceptance don't match, but the parties do perform. So the person shakes my hand and says, I'll take the car for $9,000 instead. And I give him the car. He had the last word, and his last word was $9,000. He had the last shot. Remember, this only occurs if there's performance. Battle of the Forms, that's the same sort of principle, but under the UCC, that's very complicated and convoluted. I'll make a separate video on that. But the idea here is that if merchants, say, have these standard forms that they're sending back and forth to each other and they conflict, which one of the forms, or in which terms from the forms control on the agreement. That is very complicated. We'll get into that at a different time. That's not worth getting into right now. Acceptance. It only becomes a contract if the parties accept. Who can accept? The person who the offer was made to, or an agent of that person, and only if you're aware that there even was an offer in the first place. Like we said above, the acceptance must match the offer. That's the mirror image rule. And it only stays open for a reasonable amount of time. So if I say I'm going to sell you my car, you say I'm going to go think about it, you come back to me in an unreasonable length of time, months later, many, many weeks later, year later, then it's over. You can't have people just out there with open offers forever. It has to be made within a reasonable period of time. How do you communicate the acceptance? It can be express. Yes, I will take the car. Or it can be implied. You could just say, here's a check, here you go. And it's implied. The mailbox rule. Now, this is kind of interesting, I guess, but it's the idea is if you are accepting a contract by mail, the rules. When you send an acceptance, the second you put it in the mail, the contract is formed right then. And there are a couple different options. What happens if, for instance, you put the acceptance in the mail and then you also put a rejection letter in the mail? Because remember, just when you put something in the mail, the person doesn't get it immediately. There's some lag time in between. So what if you put an acceptance in the mail and an hour later the person calls you to revoke or something of that nature? A lot of this is outdated with email and phones. This is antiquated stuff. But let's go through it just very quickly. Like I said, I put a letter in the mail that says, yes, I accept. The second I put in the mailbox, a contract is formed. Now, one tidbit is, unless in the offer we contracted out of this default. We said, until the letter arrives or something like that. But the default rule under common law is the second I put the letter in the mail, there's an acceptance. But what if there's a revocation after I sent the acceptance? The difference is that a revocation is effective only when it is received, whereas the acceptance is effective the second you put it in the mail. That means you can actually accept by putting in the mail. The next day before my letter arrives, I get a revocation. Doesn't matter. The contract has been formed. What if I send a rejection, then change my mind, and then I send an acceptance letter? The mailbox rule kind of goes out the window here a little bit, and this is weird, but it's whatever one arrives first controls. Again, what if I send an acceptance letter and then change my mind and send a rejection letter? Well, we said that the second you put the acceptance letter in the mail, a contract is formed, right? Which means that a contract was created when I sent the acceptance. The only instance when this might be different is if the rejection letter got there first and the person relied on that rejection. Now we're going to go to part 3. We're going to talk about contract formation and issues along those lines.